Testing, 1, 2, 3. Testing, 1, 2, 3.
Well, good evening, everyone, and welcome to our evening town hall. I trust everybody can hear me. And hopefully, any thumbs up to make sure I'm being heard? Good, all right. So thank you, everybody, for joining us, and I'm hopeful that a few more will join us as we proceed, but I'd like to get this whole thing going at this stage. Uh, Ms. Wade, is there any formalities you want other than me just to say welcome and introduce our lead speaker guest?
That's everything you need.
All right. So we're just going to go ahead and say welcome to all, and I'm going to turn it over to Mr. Rod Northey. He is the lead counsel we had on our OLT appeal launched by Oak Bay Developments, or OBD. And Mr. Northey, if I can just pass it over to you to give us a quick oversight as to what has taken place and what is in process, and then we'll turn it over to the questions that we have received. Thank
Sure.
you.
Thank you very much, Mayor. And good evening, everybody. I don't think most of you have ever met me or heard of me even, but I'm going to do a very brief presentation. I recognize that you have questions, and I'm not going to try and take up too much time with a presentation, but let me start with a bit of an overview. I'm going to share a couple of slides with you. If we can move the slides forward. And I hope I will be done in about 5 minutes. And certainly you can ask questions on the slides that I present. And let's just go to the next slide. This is what I'm up to. So I'm going to focus tonight just on what happened at the tribunal, and then provide a little bit on what the township's done since then, which is to say the township has gone off to court to seek leave to appeal to the divisional court on what the tribunal decided. And the township has also reached out to the Ministry of Environment. I am going to focus on what's going on in the court part of this, but I just wanted to give you a bit of sense of what the township's up to. So the key point is any of you who have read the decision, the tribunal granted the appeal of Oak Bay Developments, or OBD Developments Inc, or Oak Bay is what I'll call them tonight. And in that means they allowed the required rezoning to permit the temporary crushing of aggregate on a residential site. Those who have read the decision will, I think, agree that the concerns of the township were not met, and nor were the residents that participated in the proceeding. So as I've said, we have initiated a leave to appeal motion to the Ontario Divisional Court, and we've reached out to the Ministry of Environment. I'm going to focus on what is going on in that leave to appeal. So the next slide, please. So this is just to say what the tribunal decided, and many of you will be familiar with this, and we can come back to this. I could spend some time on this, but I don't want to. It's just to say, here is what the tribunal said in order to decide the appeal can be granted. Probably the most important thing about this is that there are a number of conditions where the tribunal has recognized that, things can happen so long as certain mitigation measures are carried out or implemented. I will come back to that. So that's the key finding. What's the problem with that? And now let's go to the court process. Next slide. So the court process takes place because there's something called a leave to appeal motion on issues of law. So it's a three-part test. The proposed appeal raises one or more extricable issues of law. There's good reason to doubt the correctness of the decision with respect to the issues, and the issues have sufficient general or public importance to merit the attention of the court. And importantly, the court is entitled to assess whether the tribunal's treatment of issues of law was correct. There's no deference. So what are the issues the township's raising? I'm going to try and do this fairly quickly. Let's go to the next slide. One issue, I've issued this as first, second, and a few others, but really the priorities there are multiple issues here. But one issue is that the whole decision, if you read it, it provides an approach to mitigation that's beyond what the scope of temporary zoning provides under the Planning Act. Zoning, as most of you would know, is normally a yes-no decision. A use is either permitted or it's prohibited. For temporary zoning, section 39, which is the provision authorizing temporary zoning under the Planning Act, permits conditions on the time frame. For example, can the temporary zoning last 6 months? Can it last a year? Can it last 2 years? So that's certainly permitted. But here the tribunal made a number of findings that require mitigation of crushing impacts, but provided no bylaw to implement the mitigation it says is needed. And section 39 provides no basis to attach mitigation measures as conditions to the temporary zoning. In other words, the tribunal has provided a decision without implementing the very things it says are essential to implementing the decision. We say that is an error of law. Second issue, next slide, please. This is a bigger deal, and I'm not going to spend a ton of time on this, but this is a whole question of the provincial policy statement. In law, the tribunal has to make its decision consistent with the provincial policy statement. The township raised a number of issues with that policy statement, particularly on the issue of land use compatibility. I've briefly mentioned these policies. Policy 1.1.1c seeks to avoid development and land use patterns which may cause environmental or public health or safety concerns. The tribunal did not deal with that policy. We put it in play, the tribunal ignored it. Policy 12.6.1 seeks to avoid potential adverse effects from the emission of contaminants from major facilities on sensitive land uses. The tribunal adopted an unprecedented meaning to the term major facilities so that it would not apply to the rock crushing operation. I've provided the definition here, but again, in interest of time, I'm not going to cover that. It's just to say we are appealing this unprecedented definition because we say the meaning of that term is supposed to be broad and not to exclude crushing. Next slide, please. So the other issues of law, I've just provided 5. Contrary to the 2020 provincial policy statement, the tribunal ignored entirely the emissions of toxic particulate matter 10 and 2.5, that has no threshold for adverse effects on human health. The township led evidence on this. The tribunal ignored the entire issue. Next problem, the tribunal failed to ensure that the proposed site alteration, located in the habitat of endangered and threatened species and adjacent to significant wildlife habitat, was consistent with PPS policies 217 and 218. Next, the tribunal failed to comply with Section 24 of the Planning Act by approving a bylaw that doesn't conform to the township official plan policies that prohibit aggregate crushing in the Severn urban area or within 1,000 meters of a residence. Next issue, contrary to Section 14 of the Municipal Act, the tribunal relied on a definition of construction under the noise bylaw, a Municipal Act bylaw, to overrule the conflicting terms under the township's own zoning bylaw for a matter that involves Planning Act zoning approval. Why was the tribunal even talking about the Municipal Act bylaw in the first place? Last but not least, contrary to the requirements of the Planning Act, the Environmental Protection Act, the tribunal relied on EPA regulations to govern a Planning Act approval. Again, what's the authority for that? So those are the issues, and I think I've exhausted the amount of time I wanted to spend on this. So I will leave it there. The final slide is just to say who I am and the colleague I'm working on, Graham Reeder. But that's it, ladies and gentlemen. I look forward to hearing some questions from you, and thanks for your patience. I hope this has been helpful.
Well, thank you very much for that. I'm going to say, first of all, to all our participants, if you'd be so kind to raise your hand if you have any questions, and then our clerk will move you on over. So please, anybody have any questions, then please raise your hand, and then the clerk will move you over, and we'll hear what you have to say. We did receive some written questions, and I'll get to those shortly. But I'm asking right now for the participants who want to speak to raise their hands, and then they can be moved over. One of the questions, and I'll ask that of Mr. Northey, is based on the OLT decision. There are certain restrictions that are being placed on Oak Bay developments with regards to if they go ahead with the rock crushing, such as maximum 60 days
Right.
within certain hours and all that. Who will be responsible to make sure that they do not exceed whatever limits that the final decision may hold?
Well, thank you very much, Mayor. That is a very important question, because that's one of the issues why we're appealing this. It is not at all clear who is supposed to do this. If you read the decision, you think the tribunal believes the township should be the one enforcing this, but the tribunal's decision provides no mechanism for the township to do that. And the township's legal position is that the temporary zoning, is not a mechanism to provide those kinds of enforcement. So that is a problem. That's one of the reasons the township's appealing this, is because the township is very concerned that the mitigation the tribunal thought was necessary can't be enforced against Oak Bay.
All right, thank you. And while we're waiting for the participants who raised hands to be moved over, another question is, given the appeal by the township of the OLT decision, any idea of a timeline that people will be looking at to get this issue resolved?
Well, another great, very timely question, because
I'm just reading them.
Earlier today, the court has convened a case management conference with ourselves in Oak Bay for a week Friday, in order to discuss exactly that question. And the key question is, when will there be a hearing day assigned by the court? The court wants a case management conference and has said expressly that one of the purposes of that conference is to set a date for that hearing. So I don't know today. We had both sides had agreed for an expedited hearing. What that means is not clear, but a week Friday, I expect there will be clarity.
All right, I'm going to go with one more question before, because I haven't seen anybody moved over at this point. What potential role does the MECP have in this going forward?
Well,
the Ministry of Environment, Conservation and Parks.
Yes, thank you. I know it's an acronym. It's a game of acronyms. I'm glad you stepped out of the Mayor. So the ministry has a couple of roles here, as we understand it. Certainly the role that the tribunal identified, and we agree with, is a role regarding the Endangered Species Act issues that arise here, because the site is identified habitat for the eastern fox snake. So the MECP has a role in dealing. It's the lead role. It used to be, for those who have followed this along, it used to be the Ministry of Natural Resources Forestry was lead on endangered species. That changed in around 2015 or so. It's now the Ministry of Environment, Conservation, Parks that's lead on endangered species. So that's one role the ministry has. The other role that's a bit less clear at this time is the ministry's role regarding any Ministry of Environment approval for the air and noise emissions. I can't really speak to that. The township has been in discussions with the ministry. I've not been part of those discussions, but that is another aspect of what we think the MECP has a role in. And again, we're just waiting for some clarification. So it's two things: endangered species and the question of approval by the province for noise or dust emissions related to temporary crushing.
All right, thank you very much. One final question. Was there any discussion in all this about what water will be used for the damping, where it will be coming from and where it will be going?
Well, the short answer is no, but that fits in again to the category of mitigation of various effects associated with crushing. And as I say, the broader problem with that is that we don't think temporary zoning is legally the mechanism to implement those kinds of measures, those detailed mitigation measures, which raises a problem conceptually and legally with how does this approval allow Oak Bay to proceed with the mitigation the tribunal thinks is necessary. So water is just another aspect of conditions that seem to be important to mitigate effects, but there's no mechanism to enforce it.
All right, thank you. To all our participants, if with your hand raised, we get something on screen that says you'll be promoted to a panelist. Please accept that. Otherwise, we won't see you and we won't be able to hear your question. So with your hand raised, and if you get on screen, we're asking you to be promoted, we will go ahead. And Councillor Graziano, I'm going to go to our other participants before we get this to council, because I'd like to get their chance to get something in here. So I see Mr. Miller, and Mr. Miller, I'm going to go to you first, please.
Yes, thank you. Thank you, Your Worship. I had trouble unmuting and Mr. Northey, thank you. I did watch pretty well the entirety of the proceedings, and I think I understand the nature of the call and what the appeal is. I have a very specific question about what was put in as evidence from Oak Bay and potentially from the town. The setbacks for both the dust and the noise were always attributed to residences, either across in the trailer park or in the Clap Trail area or even in the Oak Bay subdivision. What astounded me was the entirety of the eighth hole, the ninth hole on the golf course, the seventh green, and the major thoroughfare Golf Course Road, which has a continuous flow of pedestrian traffic, including babies and carriages, is arguably within a third of the setback of the nearest dwelling. And I recognize there's differences between time-weighted loading and peak loading, but I can't understand how peak loading for the crusher startup for dust or potentially the continuous running of the crusher didn't include those innocent either residents, tourists, or participants in the golf course. Those people are going to be subjected to orders of magnitude higher exposures than anything that was talked about in the tribunal.
All right, well, that is a very good question, and so let me try and answer it in a legal way, the way I understand it. It may not satisfy you, the answer, but let me give you the legal part of the answer. The legal answer is that the way we are trying to deal with noise and dust impacts of the crushing was through a policy in the provincial policy statement that I mentioned in my presentation that seeks to avoid adverse effects from major facilities, which we consider the crusher operation to be, and here's the key point for your question, sensitive land uses. Sensitive land uses is a defined term in the provincial policy statement. And I'm not sure, and I'm not going to say anything more to you to definitively say how this works, but I don't believe that the pedestrian traffic you're describing fits the definition of sensitive land uses in the provincial policy statement. It's not to say, I'm not trying to make a point to you, sir, about whether they will be affected. I'm really just trying to explain the policy framework that we applied using provincial standards and provincial policy. So I think that's where the answer lies. And if there is more to this, it will be in what the meaning of sensitive land uses means. I hope that helps you.
Well, thank you for the answer. I think I understand it, and certainly directing this towards the town. If there is some remedy down the road where this is going to be an active site like that, I would expect that whatever zoning rules, enforcement rules, and the engagement would have to include providing PPE for pedestrians and having the golfers trained and have proper hazmat suits or whatever is required for those people that are in close proximity. They would be in the same category as a worker running the crusher. So I don't know how that pans out down the road, but it can't be ignored.
No, I'll leave it there. I think you've heard my legal answer. I understand exactly what you just said.
Thank you.
All right, thank you. Whitney Miller, please, followed by David Clark.
Good evening, Your Worship. Thank you very much, and Mr. Northey for coming on. We watched with interest the proceedings, and actually was quite appalled by the conduct of the chairperson and what I perceived as an obvious bias towards Oak Bay. My question is actually, I submitted my wife submitted a number of questions, but I think for everybody who lives in this area, could you kind of outline the next steps in this process as to what it actually means? For example, there was the OLT, the outcome of that versus now going to Ontario Court. I'm not sure if it's Ontario Court of Justice or Supreme Court of Justice, and what the process is there and why that actually carries a lot more weight than an OLT decision.
Well, okay. I'm laughing because you loaded up and your question was proceeding along in a fairly neutral way until you loaded it up at the end. But let me just let me give you the process because I didn't do much with that. I just said that next week there is a case management conference with the parties that I'll be participating in to set a date for the hearing. So that hearing, sir, is to deal with whether the township gets leave to appeal. And if the hearing goes the township's way, the court says, yes, there are legal issues that worthy of appeal, then there would be a hearing in front of a three judge panel of what's called Ontario Divisional Court, which is an aspect of the Ontario Superior Court of Justice. So it's a two-stage hearing process, if I describe it that way. First, to see if you get leave, and then if leave is granted, to set an appeal. In this case, both parties have agreed to try and expedite things. That doesn't necessarily mean much right now because I don't know what expedite means till a court tells us. But I expect we're going to get a date in the fairly near future on leave, and then from that, a date on a three-person panel if we get leave. So that's to say, sir, if we succeed in all of that, there are two stages here, that would set aside the tribunal decision, in which case OPE does not have temporary zoning appeal, period. Now, alongside that is what's going on with the Ministry of Environment. And that's a bit more complicated because I'm not the one acting for the ministry. They have their own legal counsel, and I'm always loath to try and speak for somebody, other parties. But they do have a role on the endangered species and what happens here. There are some pretty serious issues the township's raised on that, and the ministry's got a lead in dealing with that. And then secondly, there appear to be some issues the ministry has on whether there needs to be a further ministry approval on aspects of the noise and dust. So that's sitting with the ministry independent of the township's interest, although the township has been engaged with the MECP directly, and I am expecting that to continue. The township wants to work with the ministry and the ministry vice versa. So those are two tracks is probably the best way to put it, both of which are oriented to trying to get to the bottom of, should this crushing ever proceed? And if it proceeds, under what conditions? And the township has some pretty serious issues with the second scenario. If it proceeds, under what conditions? So I'm optimistic or hopeful that we're going to get the first part of this addressed, which is to say, this is not the right thing for temporary zoning, and there are other issues with the tribunal decision. That's a long answer. I apologize for that, but I hope that's helped.
No, it is helpful. And, again, thank you for the due diligence that you took and the presentations you made, although it seemed several times the chairperson seemed to ignore. And I guess in the OLT there's no set court proceedings as there would be in a real court. So thank you.
Fair enough.
All right, thank you very much. Ms. Miller, your turn.
Good evening, Mr. Mayor, council members, and Mr. Northey. Thanks for having this session. I think I have a fairly straightforward question. Could you just confirm for those of us that had participant status during the original OLT hearing, if that status will be carried over, or is there another step that we must take?
Okay. Yeah, that has not been covered by anything I've addressed. So your status as a participant was strictly before the Ontario Land Tribunal. In the matter of going to divisional court, that status is not maintained. You don't have any status now. Should you wish to have status in a court proceeding, and I think the leave one is premature. I don't think I've heard of interveners for that. But let's say that the leave goes the way the township hopes it does, and there is an actual hearing before divisional court. You would have an opportunity to seek what's called intervener status at the court. That's a pretty serious step, and it's quite a bit more advanced than participant at the OLT, because you generally would need to have legal representation to be even an intervener. But without getting into all the details, that would be a step that you could take if the township gets leave to appeal and there is a hearing before a panel. I hope that answers your question.
It does in part. So I'm presuming you will provide notice if you're granted that leave?
I
some
fully
sort?
expect the township wants to be transparent about this. Yes. So they will be on the township website, I will presume as soon as we are aware of a decision.
Okay, thank you very much.
All right, thank you. Councilor Graziano, did you have a question, or was your hand raised in order to get on screen here?
The latter, Your Worship. Thank you.
Okay. I'm asking for the attendees if there are any more questions. And while we're waiting to see if hands are raised, let me go through some of the correspondence to see what questions haven't been asked. And I apologize. Now, here's one that I never expected, so I'm going to ask it because it surprised me.
Oh, Mayor, I'm looking forward to that question.
Okay. This was from a float pilot who wants to know if the Transport Canada has to be contacted with regards to this operation taking place so close to the water.
Wow. Well,
Told you I'd surprise you.
You did surprise me, and I'm not going to pretend that I have an answer for that one. I think, Mayor, what I'll ask is that you provide me that question and I'll try and figure out the answer to that. I'm not aware of that kind of restriction, but I have not investigated this, and I'm not going to give you a black and white answer to something I haven't investigated. Good question. I just don't know the answer to that right now.
And I'm going to sort of paraphrase one of the other questions here is, given that some of the rocks may be too large even to be crushed with the crusher, they'll have to be broken up beforehand. And given that there'll be lots of equipment around the site, if approval if the final decision includes approval for crushing, will that include control over the breaking of these rocks that are oversized and the equipment being used and whatever oils they have or anything else that they may be contributing to the call it environmental hazards?
All right, that's another lovely question. So let's do it this way to understand this. Legally, we are considering, and I'm speaking for myself, we call it the crushing operation. And what I mean by that is it's a global term to cover all of the equipment that is required by Oak Bay to carry out the crushing that they're intending. And it's more than just crusher. They need loaders and they need other equipment to move things around. Whether they need another piece of equipment, Mayor, to break up larger rocks into smaller, that would all be encompassed in our concern about the crushing operation. So it's not just one piece of equipment, it's the whole operation required to take the rock that is there on the site and turn it into the crushed material that Oak Bay wants to use. I think there are a number of pieces of equipment, and we are concerned about all of it and how all of it gets properly regulated, because all of it can cause dust and all of it causes noise.
Another question, if and again, many of these questions are if the rock crushing goes ahead.
Yes.
If the rock crushing goes ahead and they're permitted to crush for 60 days in the next 2-year period, which is what they've asked for, are they limited to crushing the rock that's currently on site, or can they either bring more rock in for crushing during that period and or excavate more rock underneath the current rock pile for crushing?
Okay. Some good questions going on here.
Hey,
so the first thing
again,
to clarify,
I'm not going to take credit for these questions. I'm just reading them.
No, so let's clarify. There was a map provided by Oak Bay at the hearing that showed the various subdivisions that are in play, including which subdivisions are built, which ones are in constructions, which ones are yet to be constructed. There are more subdivisions to be constructed than simply the Somerset site where all the rock's sitting. All of those operations may and very likely will give rise to excess rock, which is exactly the rock that has given rise to crushing. So one might imagine that this is not the final state of crushing at Oak Bay proposed now, but in fact, there would be a further request for further crushing in the future if this approval is granted. That is not clear at all from the documents at the hearing, but that is how I have looked at it, because we seem to be dealing right now only with historic rock that is gathered already at the site, not the future rock that will be crushed or will be generated in the future by future blasting and moving operations. So I think it's a bit of a moving target. That's how I understand it right now.
All right, thank you. We have a couple more questions from our audience, and I have Anne's iPad. So Ms. iPad, please go ahead. That's you, Anne.
Oh, sorry, I guess you couldn't hear me.
Now we can.
Yes, it's my question is, we spent a lot of time getting petition signs and getting people to write letters when we were originally fighting this. And so is there anything we residents can do now?
Well, I think the very fact that I've been retained and I'm fighting this in court on behalf of the township, I think is testament to what you have achieved and got the attention of the municipal council. So I don't think it's a small thing what has already occurred as a result of your concerns and the efforts you've made. Going forward, I think there's a lot more to say. We are proceeding in a legal forum, but other discussions are occurring with the Ministry of Environment, as I've alluded to, and other things may come back to the township depending on how the legal proceedings go. So I don't think by any means your role is over, but it's hard to say right now what the role is, because the priority right now is to focus on, is the tribunal decision lawful and upheld such that there will be some crushing taking place, or will the township's concerns with this prevent that from occurring? That's the big issue for the moment, which is in the courts. But as I said, I expect there may be things that come back on this in the future, and your historic interest, and I mean your is a global number, all the historic interest in this has certainly given rise to people like me getting involved on the township's behalf. So I hope that assists.
Thank you.
All right. Mr. Northey, you offered us a half hour and we've reached that limit. I think that if you can give us a couple minutes more, we'll go to Mr.
Yep.
Clark has another question, and then I'm going to thank you for your time.
No problem. Thank you.
Thank you, Your Worship and Mr. Northey. Actually, this one is on behalf of Gary Philipchuk and his wife Sheila, who are having trouble getting on as a panelist. And Mrs. Philipchuk is down on Clap Trail at the end and is wheelchair bound. And the concern is, should the rock crushing go forward, that she will be tethered to her home, and what is going to be done for her, because it means that she can't go out, she can't go get the mail, she can't go out on her deck, all these different things because of her disability. And that's
all right. Her disability and the issue of the noise and the dust associated with outdoor air quality. So we're a few steps away from trying to figure out how to deal with that, if I might. If the crushing were to go ahead, then what you're saying, it becomes an issue that does need some discussion at the township level. But at this point, as you know from the whole exercise of my presentation and what we're doing, is we are appealing the legality of what this crushing approval was. So at this point, I don't think we worry about that. I do recognize that name. I will say, whether were the Philipchuk's participants or something, I'm very familiar with the name. So I do appreciate the concern, but right now, in sort of related to what I said to the last question, we are focused on trying to get a legal resolution of this. The questions you're raising will be much more relevant and germane if we don't succeed in dealing with the crushing the way that we're hoping right now. So it's a very important issue. And let me just say, I think you saw in my presentation, the health issues were ignored by the tribunal. The township's not ignoring those in this legal appeal.
okay. And thank you for that. And again, I think you've just said, my other question is in relation to, if we weren't successful with the court in the past, who going forward would be responsible? You made reference to hazardous materials, which is my background, and in relation to where monitoring devices would be for both air quality, noise, and runoff, and who would be, we'd like to see ensure that, again, if it's unsuccessful, an independent third party who's going to hold them to task on that with random inspections, data logging, and ensuring that all that information, as we said in the whole process, is transparent and would move forward and be available to the public through the township. So again, I know it's putting the cart before the horse, as you've said already, but just things that do need to be considered, moving forward, because Oak Bay seems to have ignored all that. In fact, today, one of my neighbors was telling me as they're again breaking up rock for putting in sidewalks, there was dust everywhere and no mitigation to be found. So just another perfect example.
Right. Well, let's just say then, I think you've got the gist of it. We're first things first, as you put it. Those issues are part of the appeal because we think they're complicated. The conditions that will be required for this to occur in a safe way are complicated and were not addressed by the tribunal. So let me just say that we don't think where we are right now is adequate. What then happens if we don't succeed on the appeal, that's another discussion, sir. And I expect you will be in front of Township Council again to talk about this, but it's certainly important, and it is not, the very point you're making is not ignored. It is part of the appeal.
Okay, perfect. Thank you. Appreciate it.
Councillor Graziano, do you have a question on behalf of a constituent or for yourself?
I have a follow-up question on behalf of constituents, specifically in the questions that they had fielded my way. And if I may, Your Worship.
Go ahead, please. And this will be
Thank
the
you.
last question, and then we'll say thank you very much to Mr. Northey.
Mr. Northey, as I articulated, I had received numerous questions pertaining to a specific submission of evidence in one of the parties that had participated and had received party status. In that, it was, I believe, Dr. Dina Brooks, who is I believe, based on my research, one of Canada's leading pulmonary scientists, and also the dean of, or vice dean of medical sciences at McMaster University. She had spoken to the issues with regards to silica dust and the impacts it can have on human health. I'm wondering, based on the community and the inquiries that I received around this question, should the municipality be granted leave and appeal filed, could Dina's testimony be called as evidence in the appeal, or could Ms. Brooks be invited in to speak to the matter on health? Okay.
So important question. So let me just say, I don't recall the evidence of Dr. Brooks. So if evidence was before the tribunal, it is available for any appeal. So that's easy to say. It's available. If was not at the tribunal, but for example, was said in submissions to the township in testimony, but did not make it into the record that I have seen, so is not part of what was in front of the tribunal, that's more of a problem for the court process, because the court process is an appeal of what the tribunal got wrong, as opposed to an open hearing, a new hearing about everything and the merits of everything. So that it's really a different question if the evidence is there or is not there. We are, I'll just say in a general way, we are aware, because of the air quality expert that we did call, or the township did call, aware of silica as a health issue, particulate matter 2.5 and PM10 I've already alluded to. Those are part of the record right now before the tribunal, which I said earlier the tribunal had ignored. So, and that part is in front of the court, or would be in front of the court on any appeal.
All right. I'm going to say to Mr. Northey, thank you very much. We greatly appreciate you taking all the time and giving us an extra 10 minutes. I'm also further going to say to all our attendees, thank you very much for your questions, the ones that have been spoken here and the ones that were sent in. I apologize that we didn't get to all of them, but hopefully you got enough of the answers to have some idea of what is going on. And I'll say to everybody, please feel free to write counselors, staff, if you have any further questions. And as Mr. Northey said, that we will probably be getting an update in the next week or two as to next steps that might or might not be happening in the short run, and we'll keep you posted. And again, thank you very much to everyone, and I hope you have a good evening. Thank you.
Thank you. Good night.